Tuesday, and welcome to another edition of the Daily Objective. I am James Valliant, and today I am joined by Joseph Tabenkin, who has been studying, in fact, a sort of a project of his to study the current case that's the Supreme Court announced last month they're taking up on the well-known pharmaceutical case, the Purdue Pharma settlement. Perhaps to just remind you a little bit of the background, this is one of the large pharmaceutical companies. It's family owned by the Starkey, I believe, family. And they were charged civilly with, and in fact, the corporation criminally, with a series of violations of federal law. For example, giving kickbacks to doctors or clinics who would use their services when they sold opiates. And of course, America is going through a giant opioid crisis with all kinds of people dying from overdoses in the last few years. The numbers have become absolutely frightening in the number of young people who have been dying from that. And a couple of years ago, a settlement was drawn up between the government, the Department of Justice, and Purdue Pharma. That settlement has been highly criticized, and the Supreme Court has put a hold on that settlement and has promised to hear the case in December. So with that as a background, Mr. Joseph Tabenkin, welcome.
Thank you.
What got you interested in this case?
Yeah, so people might be familiar with the new Netflix docuseries that just came out called Painkillers. I definitely can recommend it. It was it was a dramatization of what happened. And then there's also another book I can recommend that I did a deep dive on after called Empire of Pain by Patrick Keefe. So he goes into a lot of detail on the Sackler family who owns Purdue Pharma and the opioid crisis and what happened there. And so that just got me interested. And in particular, what I find interesting is where the lines of legal liability can be drawn for a corporation, where those lines can be drawn, in particularly when the corporation or the employees of the corporation engage in criminal behavior, and some other details about the Supreme Court case that we can get into. And maybe I'll provide just a bit of specifics on what Purdue Pharma actually did that might be considered criminal behavior.
Why don't we start there? Why don't we start with the allegations against Purdue Pharma and what this family and corporation were alleged to have done? One of the things I mentioned, for example, was the kickbacks. In another, there are several things apparently they did to. First of all, they fraudulently misreported things, as I understand it. There is a very complex regulation. People should know in the background, there's a very complex system of regulating drugs, scheduled drugs, for example, opioids and other pharmaceutical drugs. You can't just walk into a drugstore and get it like aspirin, like an over-the-counter medicine. You have to be prescribed it by a doctor. Some drugs can't be prescribed at all. It's just criminal to have. But other drugs can be prescribed by doctors, and those prescriptions, those drugs have to be approved by the Federal Food and Drug Administration, the federal agency that regulates these things. And they have to go through a process of proving that it's safe and effective and so forth. And there are several, not only is there the prescription laws, but there's also the medical licensing laws that can be involved, the Food and Drug Administration's permissions, but then also the Drug Enforcement Agency, which enforces misuse of things like opioids. And for the criminal prosecution for the misuse and handling of opioids, they need to have the numbers properly given to them. And apparently Purdue Pharma misreported numbers about who was using and how much they were using of these or getting prescribed of these drugs. Can you give us more detail on these allegations?
Yeah, I think it starts with what they were actually selling. So the main product that Purdue Pharma, that really got them, took them to the next level in terms of their revenue was a drug called Oxycontin. And Oxycontin is made of two parts. Oxycodone, which is the opiate, it's more powerful than morphine, just to give you kind of the context of where this is. So it's more powerful than morphine, not as powerful as heroin and fentanyl, but it's in that family of drugs, right? So really powerful substances. And And it's made of oxycodone and contin. And contin of the Oxycontin is the layer, the coating around the opioid. And the theory, at least, that they had when they were coming out with this drug is that that contin capsule was supposed to slow the release of the drug so that you didn't get the spikes in opioid release. And so, if you inject morphine, you get a lot of opioid right away. And that's the addictive quality they believed. And so this time release capsule is supposed to slowly release the drug over 12 hours and give you like a slow burn, essentially, so that you don't feel the high. That was the claim. And in their FDA approval, I'll just read you the line that they had, was that the delayed absorption as provided by Oxycontin tablets is believed to reduce the abuse liability of the drug. So essentially what they're saying there is this time release capsule is believed to reduce people's abuse of it. It's like their addictive nature and their,
right.
Yeah, their ability to go on and abuse the drug, which is what everyone gets worried about with opioids, is that
right.
You're going to give it to people, and they're in the book Empire of Pain, he goes into a little bit of the history of opioids and how many people after the American Civil War got addicted to morphine, right? A lot of the soldiers were given morphine, they didn't understand it fully. So it's well known by this point that opioids are highly addictive. That line I read you is from the FDA approval, and you can see it's problematic in a lot of ways because of the is believed line. It's not very precise language. But I think the specific fraud component that I'm curious to get your opinion on is whether or not the is believed language is sufficient to get them out of the fraud. It's what seems to be established is that at some point, they got enough evidence that it was addictive, and they continued to promote to doctors that it was not. There's this line that they would quote that wasn't based off of actual studies done, that it was less than 1% of patients that would get addicted. And they used that line when they would go out and promote to doctors. And they would have a sales force of non-doctors selling to doctors the effectiveness of this drug that was supposedly not addictive, and despite them having internal evidence that it was. And so that to me is where a line might be crossed. And so I'm curious, what the actual threshold is for fraud, and when criminal behavior, or when the conversation of criminality can be introduced. Like, have we crossed a threshold in this particular case? I'm just curious to get your thoughts on that.
I think yes. I think that when a company misrepresents the nature of the product and what it knows about the product, as is clearly the case in the fact pattern that you've indicated here, there is intentional fraud on the part of a seller. If I know that I'm selling you a toaster, let's say, and I'm the manufacturer of toasters, and I know that this toaster has a 1 in 5 chance of exploding in your face, and I know that, and I don't tell people about the risk of 20% of the time this thing will explode in your face and cause injuries. That seems to me, and it seems to me, any latent danger to a product, now, as you point out, opioids are well known to have the danger of addiction. In this case, however, they said this is different than other opioids. It's not as addictive. And they're making a positive claim that at some point they learned was totally false, and they continued to make that claim. That is criminal fraud. That is certainly commercial fraud. Even in an ideal objectivist world, so we would not have anything like the liability system we have today. Let me give you an example. At some point, the individual their responsibility has to kick in. Our liability system totally ignores individual responsibility in many cases. Let me give you a case where they don't, where we recognize individual responsibility. Let's take the Hostess Twinkie Company. Is Hostess Twinkie or Hostess Twinkies responsible for the diabetes, morbid obesity, tummy aches of all the people who overindulge in Hostess Twinkies? Well, no, you as a consumer have the responsibility. have an occasional bite of a Twinkie without having any of those things. But you as the consumer have to regulate that. You're responsible for hurting yourself if you eat too many Hostess Twinkies. It's not the Hostess Twinkie company that's responsible. Similarly, if it was just a company producing opioids, yeah, these are opioid. Everyone knows these are opioids, and it's common knowledge that it's addictive. Then surely there's some responsibility. Now, I agree. If I come in with a back injury to my doctor, and I genuinely have a need for a painkiller, and he prescribes that painkiller, and perhaps the doctor overprescribes the painkiller so that I become addicted, there I can see the person saying, hey, wait a minute, you doctor, I relied on your expertise, and I had a valid reason. I was sucked into this rationally by your counsel, and you as a professional led me to take too much and become addicted. Now, I think there's still individual responsibility at some point that's got to kick in. But with opioids, let me say that there's a wide range of things out there. There's people out there who just take in opioids because they know they're addicted and they're just having fun and are being irresponsible. And then there's other people who had genuine need for an opioid and then were sucked into it through their doctors. And their doctors may have been sucked into it through the pharmaceutical company through a bunch of lies and kickbacks and encouragement that they knew was wrong. But it seems to me that even in the ideal objectivist world where individual responsibility kicks in, this would be a case of fraud. Does that make sense?
Yeah, that's something I'm particularly interested as a backdrop, which is, I mean, there's no doubt that the system in which this crisis has emerged is corrupt and flawed, right? From the kickbacks, the person that approved Oxycontin eventually worked at Purdue after he left the FDA. So the person at the FDA, I should say, who approved Oxycontin, eventually went to work for Purdue. That's obviously flawed.
Of course.
Yeah. But I'm particularly interested
that are designed to protect us are almost always in bed with the companies that they're supposed to be protecting us from. And there's this revolving door back and forth. So what I found really interesting was when you quoted the FDA's approval that said that Oxycontin was less addictive. So now what responsibility does the federal government have when it's formally telling everyone exactly what the pharmaceutical company wants them to tell them, of course. But of course, the FDA says they do their own tests. And they're the ones approving the thing in the first place. So when does the FDA and the federal government's responsibility kick in on this fraud? Because they were part of it too.
Yeah. And so you said something really interesting that I want to just summarize for the audience and maybe ask some follow-ups on. So it sounds like there's two main standards for fraud. If you knowingly misrepresent, that's the obvious one. Right. But it sounds like there might. So I'm saying this is not addictive, but I have evidence that it is addictive. That's just lying. But I'm curious about another maybe point you were making, just to clarify. Is it also fraud if you knowingly withhold information but don't assert a claim? So if you maybe make a more ambiguous statement, like, there are different properties of this drug that change its addictive nature, but you withhold the fact that it is very addictive that is that also considered fraud? Is that something else? Is that a criminal act?
For me, there are a couple of things here. A criminal act, it would seem to me, would have to have a very high level of either intentional fraud or a conscious disregard for the truth. A criminal level of recklessness, not merely mere negligence. Mere negligence is what you need to show in most civil liability to get money damages. To put someone in jail to get criminal damages, you need to have a much higher level of intent. And either it's on purpose, knowing falsehood, or you were so reckless that there was sort of a conscious disregard for it. But let me go back to my toaster example. If it would depend, in my view, on the latent nature of the danger. In other words, if most of the toasters out there are perfectly safe and don't explode 20% of the time, if I know my toaster explodes 20% of the time, I have a duty to disclose rather than sell a toaster where the assumption is, toasters toast bread and bagels. They don't explode in people's faces 1 in 5 times. So it would seem to me, how real is the danger? How real is the risk? And how unknown is that danger to the general consumer? If it is a truly surprise danger hiding out there, they've got a duty to disclose. They have a positive duty to disclose that this is not like This is not as safe as you might think it is. In normal expectations. Now, something like, say, like Twinkies, if you eat the whole box of Twinkies in one sitting, everybody, at some point, the individual responsibility kicks in. If I myself have messed with the toaster, or if, let's say, the toaster manufacturer says, this is an experimental toaster, and we don't know how safe it is, will you be willing to sign a waiver? Today, we are not allowed to sign waivers or, in effect, or buy a warranty of right. And so it comes down, I would limit today, and I think most objectivists would probably agree with me, would limit the civil liability of corporations in mere negligence, or in many cases, strict liability cases, to cases wherein there was some actual fault, at least negligent on civil liability on the part of the corporation, and an individual assessment. Because even with Oxycontin, there are differences between those who are just abusing the drug and they're doing it to themselves. I mean, if I shoot myself in the head, can my heirs sue the gun company? No, the intentional act of the person normally cuts off the liability of people before. And I think those rules have to be respected. And we'd come back to a world in which corporate liability was greatly restricted from what it is today. And obviously, in this case, they were taking advantage of a giant Byzantine complex system of regulations to fool people. But we are talking, I think, in this case, about a case of clear fraud.
Yeah. And so that's a good segue to my next question, which is where the lines of corporate liability are. So, my understanding of a corporation is it's an entity that's designed to limit the risks of, individuals, right?
That's you start a corporation, right?
Yeah, or one of them. Distance yourself. If the company goes bankrupt because, you took a risk, your idea just didn't pan out, you made some bad decisions even, right. You're not personally liable for that financial. There's consequences, obviously, but you have some limitation of liability. Where does that line end? Because so in this case, the Sacklers own Purdue Pharma. It is a corporation, though. They were somewhat involved in running of it, some of the family members. So where do those protections end from being criminally liable? Because what's interesting about the case, for example, in this particular context, is Purdue was found criminally liable in some cases. So there was one ruling where they were found to be, committing a crime, but no member of the company was held responsible. So no individual was named to be criminally responsible, just the corporation.
In fact, the settlement with the DOJ gets the Sarkeys, whatever how you pronounce their name, off the hook. They're now free from any further civil liability given this. But of course, they have filed for bankruptcy. Now, in bankruptcy, normal negligence in torts, those kind of torts are dischargeable in bankruptcy. Intentional or malicious torts, if I do the wrong on purpose, those are not dischargeable in bankruptcy. And that's one of the controversial things about this case. The DOJ has apparently given, in a bankruptcy settlement, mind you, civil liability protection to the individuals who may be responsible. And it's all on the corporation and a fixed amount on the corporation. And so the question here is, intentional torts, were intentional fraud being in effect discharged by a bankruptcy court saying that this family that owned the company are not personally responsible? And so it's very controversial. This sounds like an unusual settlement in that they are guaranteeing civil protection, they're giving civil liability protection to people who have done an intentional wrong that hurt people, which is normally not dischargeable in bankruptcy. And so is it an abuse of the bankruptcy process to give these people this settlement because it's a bankruptcy plus tort settlement for the harm of the opioids?
So let me just unpack what you just said, because I want to double click on that for a second. So you're saying in a normal objective process, the corporation can shield an individual from civil liability unless they committed a criminal act. If you commit a criminal act,
intentional tort, it doesn't need to be a crime. But there's a division whether or not there needs to be the tort, that is to say, the civil wrong which can include fraud. There's fraud that I can sue you for civilly. We call those torts. There's fraud that you can be criminally prosecuted for and put in jail. That's a crime. So fraud can either be a crime or a tort. The tort of fraud, intentional fraud, is normally not dischargeable in bankruptcy. And normally, the corporation, the protection of this corporate liability can be pierced. You can, what they call in law, pierce the corporate veil to sue the people behind the company so that this corporate protection, it doesn't stand. Now, there's rules about when you can pierce that corporate veil, and a lot of them come down to, was it intentional and malicious and on purpose on the part? Well, that's exactly the kind of thing that's not dischargeable in bankruptcy. It's exactly the kind of thing where you might be able to pierce the corporate veil and get to personal responsibility. And yet the DOJ here has a settlement that gets the family off the hook for any further civil liability and has a fixed amount of, I forget what it was, $4.5 billion or something to get to the, to make the settlement. Does that make sense?
Yeah, totally. And so your perspective, my question for you too is your perspective from an objective sort of legal system. Would that still be the case? It seems legitimate to me that yes, there's a valid role that limitations of liability have, but if you intentionally act in a fraudulent manner or in a malicious manner, you shouldn't have that protection anymore. Is that your assessment, right?
Yes. In this case, this family closely owned most of the shares of this company, maybe all of them for all I know. And a couple of these people were highly involved in the company. They were medical doctors and they managed the company and knew everything about it. If you know everything that's going on, if you're a medical doctor behind this company, if the company is closely owned by a family and it's intentional wrongdoing, that's exactly the circumstance under which the corporate liability protection can be pierced under our legal system. And I would say an objective legal system would say that as well.
Okay, that makes a lot of sense. And so in this particular case, it sounds like what the Supreme Court is looking at is whether the DOJ can even offer this sort of protection, right? Should they be allowed?
A real abuse of the bankruptcy law, right? A real abuse where intentional wrongdoing should not be dischargeable in bankruptcy. And this is intentional wrongdoing.
And this seems like a really important case. And now I have a better understanding of what's at stake here. And I think the concerns that people have raised are very legitimate. So a lot of critics have said of what the DOJ is doing is that you're essentially allowing corporate owners, people who own corporations, to hide behind this bankruptcy where they can do wrong. Like they can intentionally now do malicious things in the future and not be held liable. It's the corporation that they can hide behind.
That's it. And the DOJ is sort of putting a stamp on this thing that protects liability. Do we have any super chats at this point, Daniel?
Yeah. So there's Catherine. She says she's taken Oxy many times and she can attest to there not being a slow burn. So in her experience, yes. There's no slow burn. And one of the things that's really just gross about the whole case is Purdue knew that you could just crush the tablet to get the entire hit of oxycodone
thing, right?
And in fact, on their labels, they essentially had a how-to manual to abuse it because they said, do not, they had to put on the label, do not crush the tablet. You would get more intense. Another thing that was posted is, wouldn't Elizabeth Holmes as Theranos be a good example of this? Because she did go to prison. Even though she was acting on behalf of the corporation. I guess that is a good example where she committed legitimate fraud and the corporate liability protection
fraud. You commit intentional fraud and someone gets hurt, you're on the hook. And that shouldn't be dischargeable in bankruptcy. And if it's malicious by the corporation and you were involved in the management there, we should be able to pierce the liability and the corporate liability protection and sue the person.
So I have one more question for you. Maybe we can sneak it in if we have time.
The
last question I have, this idea of the third-party release that also seems to be part of this, where once this is settled, if they settle it, no one else is allowed to sue Purdue. And that seems a little wonky to me too, that let's say I am not part of this civil lawsuit. Let's say, James, you're suing Purdue and you guys settle. How can a judge say that no one else can sue if I was also wronged? Can't I also bring my own suit against Purdue?
Yeah, that's what's one of the wrong things with class action suits and collective responsibility in my mind. Just as the individual who's been harmed, there seems to me a whole bunch of justice should be individualized. There's a big difference between the individual Oxycontin users, and that should be a matter of individual justice, but it should also be a matter of individual justice on that side as well. So we shouldn't have a settlement that says no more liability for the company. It should be a matter of when the harm actually comes up and an individual case by case basis. That's my position. I oppose, in most cases, class action suits. In most cases, I want there, though, to be waivers and warranties available voluntarily, but I want individualized justice. Whether
I see. So that's actually a flaw of the current legal system.
Very much so in my very,
you
very
can make
much.
a settlement that bars the company from being responsible for any other harm.
How can you bar my harm 5 years from now? Right.
Sure. Yeah.
Daniel,
that makes sense.
Unfortunately, we're running out of time here. Daniel, do we have any other super chats, or do we have any other announcements for programs today coming up from the Ayn Rand Center UK?
We have a super chat from Jonathan. Thank you so much.
Thank you.
And we have the reality show coming up in 5 minutes. We're going to do a Liz Truss retrospective since she has been elected or chosen as the prime minister, I believe exactly 1 year ago, or maybe one day here or there. And then at 7 p.m. UK time, we have the Fountainhead Book Club, but that's for ARC UK members only. But the YouTube members also have an access to the live stream session.
Well, folks, you heard it there. If you want to catch the amazing stuff that we do here at Ayn Rand Center UK, some of it is only available to paid subscribers. You at least have to join, at least on the YouTube channel, to get it. So I'd urge you to do that. Become a paid subscriber to the Ayn Rand Center UK. We're out there applying objectivism to every issue under the sun. These kind of if you find these discussions of value and importance, please do become a paid subscriber at whatever level you're comfortable with and can afford. And with that, I will thank you, Mr. Joseph Tabenkin, for such a fascinating conversation. We should do more of these.
Yeah, thank you for answering all my questions and indulging me here. This was great.
Okay, everyone. Until next time, check your premises.